Good afternoon, everyone. I call this meeting to order. Welcome to meeting number 91 of the House of Commons Standing Committee on the Status of Women. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are in person and in the room remotely using the Zoom application. Just going to remind everybody of just the etiquette when it comes to making sure we do not have our earpieces near the microphones, making sure that we put up our hands when necessary. And if we need to direct any questions, of course, we have both Chelsea Moore and Julia Nickel here that will be helping us today as we're going along through this. So let's just play with your mics, do everything properly. Let's not bug the translators. Let's be good. And raise your hand if you have any comments. I will be taking a speaking order throughout the days. Members in the room, if you wish to speak, also raise your hand. Pursuant to the order of reference on Wednesday, November 1st, 2023, the committee will commence consideration of Bill S205, an act to amend the criminal code and to make consequential amendments to another act, the interim release and domestic violence recognizance orders. Okay, I would like to provide members of the committee with some instructions and a few comments on how the committee will proceed with the clause-by-clause consideration of Bill S205. Just as a reminder, we did start it, but we had an amendment, so a lot of things go through there. As members already know, this is an examination of the bill of all clauses in the order in which they appear in the bill. I will call each clause successively. Is that how I can say that today? Okay, great, because I didn't successfully say that. So, and each clause is subject to debate and a vote. If there are amendments to a clause in question, I will recognize the member proposing it, who may explain it. The amendment will then be open for debate. When no member wishes to intervene, the amendment will be voted on. Amendments will be considered in the order in which they appear in your package. I will try to go slowly as we do this, and amendments have been given the numbers. As everybody remembers, you've got the numbers in the top corner. During debate on an amendment, members are permitted to move sub-amendments. These amendments must be submitted in writing. So just a reminder, we do know that we need legal translation, so if we're working ahead of time, let's just make sure that we're doing that. What I'm going to do is let's just get right to work because I think everybody's ready to get to work on here. Note to chair, at the meeting of December 4th, the committee, okay. At the meeting on December 4th, just a reminder of where we are from last week. So on last week, the committee, we adopted the following. We adopted Clause 1, and it was amended by G2 and G1, G1 and G2. We adopted Clause 4. We adopted Clause 5. We adopted Clause 9, and we adopted Clause 10. And we're resuming debate on Clause 2 with a sub-amendment to G3, which was moved by Dr. Lewis. So, Dr. Lewis, I'm going to pass it back over to you because we're on the sub-amendment to G3, and I will start by passing the floor over to you for discussion.
Well, the sub-amendment was quite straightforward, and it was just added in, if I could find it. Yes. So it would be on clause 2, and it would be amended by replacing line 20 on page 2 with the following: Formant has reasonable and probable grounds for the belief the judge.
One moment. I think you may be reading the wrong one. So right now we are on reference number 127-66880. It is seen as, it's the motion, yeah, so the committee stage from, did you have that one? Can I steal your page? Okay.
No.
So this is the one that you put in here. This is your amended one here. So this is the S25 as amended by you. This is what you put in the other day. So we're right now on the sub-amendment, which you put in.
Okay. I don't have that. I didn't get a copy of that. You don't have it either? No. Nobody sent it to me.
It was distributed. If everybody could check. So just to let everybody know,
From the clerk?
It's very important. So reference 127-66880. This is the sub-amendment to the clause that was put forward by Sonia. So this is an amendment to that. So it's a sub-amendment to G3. It should have been distributed to everybody. It should be in your packages. And what's the date that we can tell them?
Friday.
It was delayed, received on Friday. So if everybody could check, and we will suspend for 2 minutes so everybody can get their stuff. Does everybody have? They were calling the meeting back to order. Leslyn, you have the floor. Oh, and when, got it. Go ahead.
Thank you. So this amendment just pertains to the ambiguity that can be derived from just a person's fear on reasonable grounds, and it invokes a legal test which is usually used, which is reasonable and probable grounds, and it just strengthens it rather than just basing it on fears. It looks at the individual's beliefs, because fears are, as you know, they're very subjective, and people have sometimes irrational fears based on situations, including a person's race, etc. So I think that this is more of a neutral term that still encompasses the intent of the clause.
Mike today, I promise. I have Lisa followed by Sonia.
Thank you, Chair. I would say at first glance I'm not in favor of this amendment because I think it puts a higher threshold on the victims of intimate partner violence when it comes to being able to access a peace bond. So the original government motion, G3, would actually make it easier for victims of intimate partner violence to get a peace bond, and this amendment would put further barriers back in place. And so rather than try and make this argument myself, I'm wondering if our bureaucrats who are here in the room or witnesses would perhaps answer for us what they think this amendment would do to the legislation.
What I'm going to do is, I've got it on the list. What I'm going to do is I'm going to allow, because it may answer the remainder of the questions that are coming up. So Chelsea and Juliet, you have the floor.
Thank you for the question there. So some points for consideration. The sub-amendment relates, as was mentioned, to the test that a woman would have to meet to get a peace bond against her intimate partner. The current test set out in Bill S-205 and in Motion G3 requires she establish a reasonable fear of her intimate partner causing a personal injury. The sub-amendment we are now discussing would require belief on reasonable and probable grounds. The language added by the sub-amendment is not found in the existing peace code provisions, so it would introduce a novel concept into the peace bond regime. The 6 existing peace bonds require the fear on reasonable grounds, which is a test known to the courts and has been found to be constitutional. In the case, for example, of Boudreau from the Ontario Court of Appeal, that's one that's often cited. It's based, and there is a requirement that the person have the fear, the subjective part, but there's also a requirement that's been interpreted in the case law for the judge to objectively assess whether that fear is reasonable. So there is that that part that addresses concerns that it would be an irrational fear and so forth. The case law has addressed that and interpreted the term to identify an objective requirement that the judge assess. It's not really possible to speculate exactly what the courts would say is the difference by adding probable, but one possibility, which was alluded to earlier, is that it could be harder to get the peace bond. So you would have to demonstrate that your partner doesn't just fear on reasonable grounds, but fears on reasonable and probable grounds that they will be harmed by their spouse. So that's, I'm not sure if that helps, but those are some considerations.
So it's an extra barrier, though, to getting a peace bond.
Well, as I said, that it depends on how the courts will interpret this, because this is novel in the peace bond context. It's more common, for example, in relation to investigative powers, warrants, and so forth, which is, I think, probably where the inspiration for that term came from. But we can't say for sure, but that is a possibility.
So just could I have one follow-up? It sounds to me, even if it's not creating a barrier, it's creating extra complications that the legal system would have to work out.
it's creating something new, so that we'll have to see what the cases coming forward would interpret it as.
So I'll give you the list of speakers. We're now going to go Sonia, Michelle, Adrian, then Leslyn. Okay?
Thank you, Madam Chair. I
sorry.
agree with my colleague, Ms. Hafner. Further to this, the sub-amendment introduces a higher threshold for accessing peace bond. We need to increase options for victims, not make it harder for them to prove they need help. So I'm not in favor of that.
Adrian? Or, I'm sorry, Adrian. It's Michelle. Michelle, and then Adrian.
Just for clarification, Chair, and to our officials here, this sub-amendment comes from my colleague, Ms. Lewis, because the word intimate partner was removed in the original amendment from the Liberals. Is that correct? Through you, Madam Chair?
Leslyn? You want Leslyn to
Well,
answer?
I was actually going to ask
Ask them.
Yeah.
Okay. Go ahead. Yes, go ahead.
If it's about the intent, I might suggest that I'm not the best placed for
Sorry,
that?
I'm actually just asking the logistics, because the sub-amendment, if I understand correctly, was put forth by Ms. Lewis because the Liberals removed the word intimate partner with persons. Is that correct? Is that? Like, I do find it a little bit convoluted the way that it's written, so I just want to make sure I know that we're all on the same page, literally and figuratively here.
Yeah, I'm looking at this because I don't think that that's exactly how it rolled out. It was 81003,
Okay.
where they switched it to any person, removing the intimate partner. The intimate partner was replaced with any person. And looking at that, that's when it comes to the peace bonds at 81003. So any person rather than a person. Any person rather than a person in that one. Yep.
So I think what that's talking about is any person other, like you don't have to be the victim in order to request a peace bond. So this is opening it up. So if you're the child of someone who's experiencing intimate partner violence, you can go get a peace bond. If you're a neighbor, if you're a good friend. So it's not saying you have to be the victim in order to go for the peace bond. That's the intent of this motion.
You would still be a victim in a regard of that you are still living in fear from the attacker. So you're.
Okay, one moment.
Go forward.
I'm just looking at this specifically because as we're going through this, I believe that what you're referring to me be more in clause 1, where those things were changed. And that was the consulting the intimate partner. So that was clause 1 that had clause 1, which had already been approved.
Right.
And that specifically is where the intimate partner was removed. And what we have in paragraph 3, B1, it's where we're taking that word from to any person. Correct.
Okay, so yeah, I think what we're doing here, and I think, you know, obviously sitting on this side, like we were very upset. I was personally very upset that the victim consultation was removed from this bill, as it's the meat and it's the heart of the bill, is the victim consultation, which we heard from testimony from Ms. Diane Tremblay as well. And so I think this sub-amendment, I guess what I'm doing is asking my Liberal NDP bloc colleagues here today that Ms. Lewis's sub-amendment is trying to help a little bit from this damage control, because they've removed intimate partner and they've removed victim consultation from this bill. So I just wanted to have clarification that's why I think it's not a barrier, and that, you know, I think it's really important to support this sub-amendment, if that makes sense to everyone here.
Perhaps Chelsea and Julia, maybe you can share. I'm going to go back to the list because we have Adrian and Leah. Would the impact of changing this have an impact from the intimate partner that was removed in clause 1? Is there a correlation between the language used in 1 and 2, or 1 and 3?
So I think that there are sort of two separate issues. Clause 1 dealt with bail, the bail provisions of the code, and Clause 2 really gets into the peace bond regime, which is an entirely different sort of regime. I think that part of the confusion might be that some of the wording in 810 has suggested to be amended by G3, which would which would allow like a police officer to bring the information on the intimate partner's behalf. So perhaps there's some confusion with how the rewording happened with the term intimate partner in that provision. But no, Clause 2 is sort of distinct from Clause 1. They wouldn't have an impact on each other since they're two different regimes.
Also, the change in G3 does not stop an intimate partner from going to request a peace bond directly. It just gives them the option if they are scared, for example, to go through a police officer. And it's reflecting the language in the other peace bonds where often it may be a police officer, not necessarily the individual who needs the protection that's bringing the claim, if that helps.
Continue.
Thank you for that clarification. I guess where I'm struggling with this from is we have these, each city, my city, Peterborough, is one of them. They've declared intimate partner violence an epidemic, a crisis. So I'm not sure why we would want to remove that word. Maybe if you even added and persons. But if you remove intimate partner, what message are we sending when we're saying this is an epidemic in the country, in each city? That's my concern of this removal of this word.
I don't know if it helps, but in the subsection A of G3, intimate partner is still there. So it is clear. So any person can now lay the information or apply for the peace bond. But if you look further down, that person has to fear on reasonable grounds that somebody is going to cause a personal injury to the intimate partner or to either the intimate partner's child or their own child. So the intimate partner is still in there, and it would be a requirement to get a peace bond would be that the concern is for the safety of an intimate partner or the children. In case.
So what I want to do, because I think this is, and Michelle, I hear you and I understand, because as we're going through this bill, we understand the importance of it. If we're looking at page 4, which is, sorry, I don't want to say page 4. If we're looking at page 2 in the bill, and you're looking at the fear of domestic violence, and we're looking at what 81003 really says. In the original bill, it says a person who fears on reasonable grounds that their intimate partner will commit an offense that will cause personal injury to them, to their child, or to a child of that intimate partner may lay on information before a provincial court judge. What we're seeing from this amendment is the word turn into any. We're seeing the word intimate partner turn into another person. But though, and intimate partner is changed down here to a child of the other person's intimate partner. But the word intimate partner is not in there. It's being removed and put in with another person. So continuing with that, I think that is that kind of where we're at. It's just that word and any, and those are some amendments. Adrienne, we're going to you, and then Leah.
Madame la Présidente.
Madam Chair, with regards to that change from intimate partner to any person, I thought that we had made a decision on this last week.
That was a different clause, and so what we're doing, so yes, intimate partner would be removed because of this being from clause 1, but it's I'm just going to ask and come over to, can I come over to you on this one? Can I make you go on the mic? No problem. Okay, go take the mic and explain that. I'm just going to have Daniela, go ahead.
Thank you, Madam Chair. Alors, en ce moment, on est sur la...
Currently, we're looking at the G3 amendment. We started debating this amendment. Ms. Lewis proposed a sub-amendment. CPC 1? No, we're at G3. The sub-amendment does not have a code, but the reference number is 127-66880. My colleague will show you the text of the sub-amendment in just a moment. And so we were looking at G3 with Ms. Lewis's sub-amendment. And we hadn't finished our debate on that. So if I understand correctly, we are changing fears by believes. That's the heart of it. Yes, that's at the heart of the sub-amendment. And so that would be CPC 1. CPC 1 would be for later for the bill, but it's the same thing. It's to follow up on the sub-amendment. All right, so here are my questions. I had questions for the analysts. What would be the impact of such a change? Because by changing fears to believes, I feel that it minimizes the level of evidence needed. And perhaps you've already answered the question on what the impact would be, but perhaps fears was better than believes.
Merci pour la question.
Thank you for the question. The Ontario Court of Appeal stated that if it is believes, I'll respond in English and I'll read from a case law that was in English, or a case rather.
Croire ou craindre, ça peut être interprété.
So, believe or fear can be interpreted in a way that wouldn't be an issue, but the Court of Ontario,
Belief or an apprehension that a future event thought to be undesirable may or will occur. Alors, les deux concepts n'ont pas nécessairement.
and so both concepts do not change things significantly, but because it would be new for peace bonds, well, we'd have to see what the courts end up deciding. Do you have anything to add? Just to summarize, there's not much of a legal difference between the two, according to the Ontario Court of Appeal. For a fear and a belief, there needs to be an objective assessment.
The court has said that the test will be the same, and whether it's a fear or a belief, the court will still have to decide whether there's an objective reality to that fear or belief, and they do that by saying, what would a reasonable person in a similar situation do if they had the same facts before them? Would they have this fear or belief? And so that's how they assess it objectively. But there's no real difference that we've seen in the case law from our research between belief and fear. Thank you.
Thank you very much. We go Leah to Mark to Emanuela.
Thank you, Chair, and it's nice to be back in person this week. So just picking up on a couple of comments, I think if we're talking about epidemic, it's actually just gender-based violence. I know that has been declared an epidemic in municipalities, not just intimate, but just gender-based violence. And just speaking about removing victims, from my understanding, and I could be wrong, right now with victims, they actually have choice of usually 3 options, like a written submission, not testifying at all, or testifying. So it gives more autonomy to the victim to be able to make a choice about how they want to deal with a case. I could be wrong. I'd like to hear what your understanding is. And I think any is actually really important, because if you look at cycles of abuse, depending on where the victim is at in the cycle, they may or may not feel safe to report the abuse, even though they may be in a life-threatening situation, which is why I think any person is really important in terms of the what it was proposed by the Liberal, so that if a person even is too fearful to report, feels if they've gone through, I know you want to do a study on coercive control believes that if they report something terrible is going to happen to them, they might choose not to report whether it's true or not, depending on how they're doing. So I actually support I actually do support that amendment of having any. For that reason, I think
I just want to ensure you are on G3 and not the sub-amendment right now as you're talking about this. The word any is one thing, but it's the words to do with fear and believe.
Oh, fear.
So
okay,
right now we are on the right now we're on the sub-amendment.
Yeah, and then that was my question.
Yeah, so we vote
Is there a better word beside, because it seems to me, and maybe I'm wrong, that fear and believe is very subjective. Is there a better word that could be used that would be clearer?
So as my colleague pointed out, all the other peace bonds in the criminal code currently use reasonable fear. And it does, I understand the concern that it does sound subjective, but the courts have interpreted it as being an objective test, even though there's like sort of a subjective connotation to it. So they do need to look at it from the perspective of a reasonable person to see if they would have a similar fear if placed in a similar situation.
So out of the two, believe in reasonable fear has been tested more in court. Is
reasonable fear is the test that's currently in the existing, I think, 8 or 9 peace bond provisions, including terrorism, including organized crime, sexual offenses against a minor, forced marriage, serious personal injury. They all use the reasonable fear test.
Reasonable fear.
And it has been upheld by the courts as constitutional. In Boudreaux, it was challenged in that case as being too subjective, and the court said, we're going to uphold the provision because we're interpreting it through an objective lens.
So in that case, I think it would be better to use something that's been tested in the courts. Right. Okay. There we go. Just figuring it out, Chair.
Okay. So, Mark, Emanuela, Michelle, Lisa.
Thanks, Madam Chair. I just wanted to, or go back to, I think we're looking at the amendment from Lewis. We're looking at the sub-amendment, sorry. But I just wanted to make a few comments. One is, as Leah pointed out, and the Minister of Justice has also called that gender-based violence is an epidemic, so une pandémie, better term en français. Alors, le ministre a déjà parlé que c'est un...
The minister has said that it is a serious problem. The only thing that I wanted to come back on is Michelle's point, and going back to the original amendment, that it was removing barriers. The issue is not removing intimate partner. It's that it's adding that other people can ask for the peace bond.
That language, because if we just put intimate partner in there, as S205 states, then environment, family members, or others cannot also apply for the victims as a peace bond. So it is an amélioration. I just wanted to put that. Now, going back
Mark,
to the sub-amendment.
Yeah, let's go back to sub-amendment.
So going back to the sub-amendment, that reasonable fear has been, as we just discussed here with Leah's question. So I will be voting against the sub-amendment because the G3 has intimate partner in there and has the, if I understand correctly, has the reasonable fears in the G3. So I'll be voting against the sub-amendment.
Still on the list, we have Emanuela, Michelle, Lisa.
Can someone just confirm if it's already been covered, because I missed the first 20 minutes of committee, but was it already covered what the implications of adding and probable are? Was it already asked?
Let's take that down to the ladies down there. Chelsea and Julia, can you just help with that portion? We've kind of skirted around it, but I do think that's good to have specifics. Thank you.
So we discussed briefly earlier, if probable is added, the challenge is that it's not used to date in this context. It's used in other contexts like investigative powers, so we would have to wait to see how the case law interprets it. One of the possibilities is that it would make it harder to get the peace bond because it would be distinguishing a reasonable ground from a reasonable and probable ground. So it could potentially require more evidence of something to justify the fear. But as unfortunately, we don't know for sure because the other peace bonds all use the reasonable grounds term, so we don't have a sort of concrete example of case law using that term in the peace bond context. And in the investigative and so forth, it's quite of a different context because in the peace bond context, you don't need to have an offense already. You're trying to prevent it. It's a preventive measure. So it's a bit of a different context. So we'd have to see what the cases came out as saying.
Thanks very much. We're now moving on to Michelle.
Chair, I just actually wanted to point out, I didn't want to do this as a point of order, but to Ms. Gazan's point about what I had said. So I was saying City of Peterborough has declared an intimate partner violence an epidemic. So that was what I was saying. But then to Mark's point, to Mr. Charest's point, why wouldn't we add on then?
Did you say Saray or Charest?
Saray,
Okay.
not Charest.
I thought you were Saray for a second.
No, I'm not there. Yeah, so why wouldn't we add on then, intimate partner and persons? That would be, I mean, that would just be a conversation, a friendly conversation I would have with you if you wanted me to put it forward as an amendment. But it just, when you say that, because I hear what you're saying, and I think I understand it, but it's like, well, why would you remove that word, though?
Lisa, you have the floor.
I just want to make it all clear that the only thing that this sub-amendment does is add the word probable, which we've heard increases the barriers for women getting the peace bond. It also adds complications to the legal system because it's not a currently used legal term. So we're not only asking women to make sure it's reasonable that they get a peace bond, but that it's probable. That's just adding barriers. There's no mention of intimate partner violence in this sub-amendment. So I think we're going way off topic, and I think we should all know this. The only thing this sub-amendment does is add the word probable, which adds barriers.
So that's all sub-amendments do, though, is they take something and they add or distract from it. So the actual, when we get to G3, we'll see all of the changes that actually have occurred there because you're right, there are massive changes from G3. So let's get back to exactly what you're saying. G3 sub-amendment, the words which changes believes, unreasonable, and probable. So believes, unreasonable, and probable, that is the change of words there. Okay? That was the last. Any further comments? Oh, Dominique, go for it.
Merci, Madame la Présidente.
Thank you, Madam Chair. I'm a little bit confused with the French version. You can tell me if I'm wrong or if I'm completely off base. For the sub-amendment, in Ms. Lewis's sub-amendment, we'll call it that way. So we're adding in French, we'll be changing fears by believes. So when we look at the English version, we see believes, unreasonable, and probable. And that's quite different from the French that only has croire. And I don't have the same background in law, but it seems very different. The English seems to go further. It's not the same thing in English and in French at all. Just one moment, André, and I'm almost done. I think we need to be very careful here because it does not seem to have the same meaning in French and in English. And I understand what Dr. Lewis is trying to do. Inaudible.
Yeah. On my list, Adrienne, followed by Mark.
Dominique, tu viens de résumer.
Dominique, you summarized my questions. I was looking at the French changes, and now I'm hearing talks on reasonable and probable in English, and we don't have that in French. And that's why I'm confused, because the French and the English here don't mean the same thing at all.
That's very, very intriguing to me. So we talk about reasonable grounds all of the time in English. What is that word then? What do they use en français? Julia or Chelsea, could you share with me? What's
Nous n'abordons pas cette question-là.
Madame la Présidente, c'est que ce n'est pas.
It's just not something that we talk about, or it's not in the French version of the amendment or the sub-amendment. We're only talking about changing the words craindre and croire, so fears and beliefs.
Si avec un mot. It was the wrong thing that was done. We waited 5 days, and it was never legally translated. Anyway.
Yeah.
Guess what? I've had an amazing person just whisper in my ear for the last minute who's explained to me what we're talking about here, because looking at the words of French and English and what is accepted in French to be maybe sometimes a little bit grander or more inclusive. You get the floor again. Explain that to everybody so we know the two differences.
Bon, je sais pas si je peux expliquer.
I don't know if I'll be able to explain it entirely, but in the sub-amendment, we only see the word croire in French. But that's because we're talking about lines 10 and 11 in the French version of the G3 amendment. And in Part A, it starts with, in the French, craindre qu'une personne commette. But we also need to look at the bill. So in the bill, on page 2, at line 9, it starts with quiconque a des motifs raisonnables, so a person who fears on reasonable grounds. So we would add the words raisonnable to the changes for croire in French. It is true that we do not see the word probable in French, but the sub-amendment was translated by legal translators, and so that's what I wanted to add on that.
So, like was said, we waited 5 days to get the translation. I think the translation is done. We heard that reasonable fear is in the criminal code and been court tested. So regardless if there's one word or not, or an added word in French or not, I think we could agree that from what we've heard that we'll be voting this down. So I just wanted to, say it doesn't matter if there's a word or two missing in French. It's clearly from what the court has said, and that we'll be voting it down, so that we could go to G3.
Dominique, Dominique, were you next online? Yep.
Ben moi, j'insiste, là. J'insiste.
I would really like to insist that we focus on this. I see that we have reasonable in English, and it's in the first sentence. A person who fears on reasonable grounds. And here we will add believes on reasonable and probable, correct? I'm sure that the legal translators are great, but I'm having a really hard time with this translation. It's not saying the same thing. I will have to vote against as well, because the two versions are too different, and I won't be able to vote for a sub-amendment that I don't understand, that I find doesn't make sense.
Seeing all others, okay. So does the sub-amendment moved by Dr. Lewis, sub-amendment to G3? Oh, Leslyn, go ahead.
my understanding is that interpretation in French is a right of privilege. And I don't understand how a Francophone could vote on anything if it's not properly translated. I don't think that that's fair. I don't purport to speak on their behalf, but I think that they should at least have before them the proper context, the proper interpretation of the document so that they could vote on it. I don't think that that's fair, that Francophones should have to vote on an incomplete document.
Point of order, like
I'll get you.
you already started the vote. You called the vote.
Calling the vote. I absolutely did. Okay, I will agree with you that I absolutely did. And I am asking to retract that because, as Leslyn called the point of order, I was not necessarily fully. So I'm just letting you know, all of my eyes were doing my best working, but when Leslyn, I honestly just did not see her, to be honest. It's not that I'm trying to mess things around, but I do understand that. On to that, we have Emanuela. You had your hand up for a quick second there. Go ahead.
So this sub-amendment was put forward last week, 1 week ago from today, and the reason why we were not able to debate it at the time was because it hadn't been properly translated according to legalities, or whatever you want to call it. And here we are today, a week later, and the translation was not done properly, and so the Francophone colleagues that we have on this committee are not able to properly, interpret the bill or the change that's being made. So at this point, I would offer Ms. Lewis to retract the sub-amendment so that we can move forward with G3, because as we did here in English, it's something that only increases barriers for women and partners of intimate partner violence.
Thing down here. I don't know if somebody else, but I have a mark like this, and I don't know if it's Adrian. Do you know what that was supposed to say? Yeah, I know that. I started writing someone's name. Okay, so there was a request if you wish to remove the sub-amendment.
I can't remove a Francophone's right to be a part of this process. That is a right of privilege, and that's a fundamental right of this Parliament for Francophones to have the same information before them as we have. So even upon retracting, I just don't think that that's my right as an Anglophone to do that.
Just a little, some excellent insight here, because exactly where Emanuela was working off of, the fact that this is the way that they have interpreted it, is this way, taking the entire context of the bill, and that's the words that they have put in there. So I absolutely recognize what you're saying is the words that legal have used and the words that perhaps Dominique and Adrian and Emanuela would feel more, I don't know if that's the case, or Mark, I don't know if it's a more comfortable or not, but I hear you. So there's, yeah. We can't vote on the substance of the bill until we get through sub. The sub-amendment has to be voted on first.
We all understand that.
Yeah.
De...
Yeah.
Qu'est-ce qu'elle a dit, Lisa?
They're indicating that we can vote on it because it does, honestly, from what I'm hearing, is that we can vote on it because it does not have the support anyway, so it does not matter the way it's written, is what I'm hearing from the discussion.
Just... We're not allowed to put forward anything in this committee if it's not in both official languages. It can't even be discussed until it's been given to everyone in both official languages. So I don't understand why we're even discussing this sub-amendment and why we're even allowing it.
It's because it's in both official languages. It was submitted and has been...
Okay, so if it is, then we get to vote on it, and that's it.
Okay? I have point of, okay, one more and then we'll go. Go ahead.
Oh,
Go ahead.
I didn't know that you could say how many point of
No,
orders a
no,
person
no, no,
can
no,
make.
no, 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 no. It's just, it's okay. It's all go.
Oh, sorry.
It's all good.
Okay. My question, though, is are we voting on a accurate translated document for the purposes of my Francophone colleagues? Is it an accurately translated document? Or is there still a problem with the translation?
Yeah. It has been fully translated and reviewed by the legal department. So this is who's gone through it. So it's gone to the very exact people that make that final decision on these wordings. So if we were to go back with them, they would probably indicate these are the words of choice that may be similar.
Okay.
So
I'm going to withdraw my amendment at this time.
UC motion. Can we get UC motion to withdraw the amendment? All those in favor? All those not in favor? Everybody's in favor? Okay. So we will withdraw that amendment. Okay. What we'll now move on to is G3. And Sonia, I'm going to throw the floor over to you. I believe that we started having this discussion and it was already moved by you, but now we're dealing with G3 unamended.
Madam Chair, I said that before, and I'm happy to read the rationale again. First, this would allow a peace officer, family, friend, or loved one who reasonably believes that the accused will commit an offense that will cause injury to the victim or to either of their children to apply for the IPP-specific peace bond on behalf of the victim. We know that a victim of interpartner violence often do not report the abuse for many reasons, including fear of their abuser. So.
And before I start taking the name list, because this is where we had come back to. So when we're looking at this, page 4, we're looking at page 4, fear of domestic violence, 81003. So if everybody be looking at G3, which is reference 127488845. This is where those discussions that we're talking about, where the word another person is put in with and removed, or is put in replacing intimate partner. So I know there was some discussions where we had people confusing the sub-amendment to the amendment, but this is, let's get into this one. This is this is where that language is changed on this one that we were talking about earlier, I know. So anyone to speak on G3? Go ahead, Michelle.
I'm just going to need 1 second here. So if I'm correct in what I'm reading from Madame Sadou's amendment, she wants to replace lines 9 to 12 on page 2 with the following: any person who fears on reasonable grounds that another person will commit an offense that will cause personal injury to the intimate partner or a child of the other person or to a child of the other person's intimate partner may lay in information. So she is asking to remove what? The way that this is written here, and I guess I'm just asking for clarification.
So when I'm looking at this, when I'm looking at the actual script on page 2, I'm going to I hope everybody, I'm going to read it into the record so we know what we're comparing. Apples versus oranges here, ready? So the original content is a person who fears on reasonable grounds that their intimate partner will commit an offense that will cause personal injury to them, to their child, or to a child of that intimate partner may lay in information before a provincial court judge. And Sonia had put forward the amendment that any person who fears on reasonable grounds that another person will commit an offense that will cause personal injury to the intimate partner or a child of the other person or to a child of a other person's intimate partner may lay information.
Okay. Can I ask, through you, Chair, if Madame Sadou could give us a reason of why she's put forward this change? Am I able to do that?
Absolutely. Sonia, you got the floor.
Sure, Madam Chair. When I add this, it also, removes some elements of the proposed peace bond, such as those relating to timeliners and allowing submissions from the information regarding conditions to be imposed on the defendant to bring the procedure in line with the other peace bond provisions in the criminal code. So these elements would not only ensure consistency with other relevant criminal code provisions, but they would also ensure that the proposed IPV-specific peace bond are able to work as intended.
So Sonia, I'm sorry, I should have added more to that because I only talked about the 810, and thank you very much, because as Sonia indicated, if you're continuing to look on page 2, clause 2, G3 will appear, clause 2 impacts timeliness, which is timeliness, section 5. G3 impacts that. G3 impacts conditions and recognizance on page 3. It impacts the beginning as well as E under that one. And then if you're looking, G3 has impacts on page 4 on submissions from the informant, surrender, reasons, variance of conditions, safety and security of informant, and form. G3, that's it. So G3 actually is throughout. It has implications on 3 different pages of this bill. So we're going to start off with Kazan, followed by Frary, followed by... Oh, you were still speaking. Well, I'm tired. Like, okay. Michelle, you still have the floor. Go for it. And then I'll go on to the
Thank you so much, Chair. I guess my question is, why are we amending this bill so heavily and pulling out critical terms that consults victims, that protects victims? And when we've had victim testimony that specifically asked for this to be passed unamended, we also had, so Kira's Law, which we did some pretty amazing work on in this committee, 233, Kira's stepfather, who's a lawyer, testified in this committee and said, leave it, leave the bill as is. Diane Tremblay, who testified here at meeting 86. She said, if my abuser had been required to wear an electronic bracelet under a recognizance order pursuant to Section 810 of the Criminal Code, as proposed in Senator Boisonneuve's bill, my children and I would have been safer, and I wouldn't have had to go through these attempted murders. Believe me, you don't want to emerge unhurt from an attempted murder. You suffer the after effects for life. She went on to say, along
Point
with
of
the
order.
other...
I'm not sure if this is relevant to the amendment that we're studying right now.
So it's really relevant.
Overruled. I think it's absolutely relevant.
It's really relevant, and the reason it's relevant is because this bill is being plucked apart, but we have testimony that has said leave it the way it is. We've had testimony from a lawyer whose own stepdaughter was murdered as a result of intimate partner violence, who said leave this bill the way that it is.
Yes, Sonia?
Madam Chair, point of order.
Go ahead.
Madam Chair, just want to say, if the officials comment on their opinions with regards to the G3 amendments, what I said, that will be maybe Ms. Frary can get the answer. Please, if we can do that to the officials, they can explain.
Thank you. Thank you very much for. So what I will allow Michelle to take the floor, and we will pass it over to the officials. But she does have the floor. Go ahead, Michelle.
This question is actually for through you, Madam Chair, to Ms. Sadhu. It's actually, it is a question on behalf of the victims. It's a question on behalf of the family who has testified before us that asked that this bill not be amended. That's what I'm trying to say. That's why I'm saying this is relevant. And I'm trying to understand, because I've seen the work that we've done in FEWO, I've seen what we've done with Kira's Law, why you are gutting this bill that is taking out victims' rights, victim consultation, and wording around intimate partner when we have testimony from the victims who are asking it not to be amended. That is my question through you, Madam Chair. Why these very rigorous amendments that change the whole heart of the bill?
Okay, what we're going to do is I will go through. We have on this list, we have, golly gee, do I have Mark next or do you have Mark next? Oh, okay. So Leah, Mark, Emanuela, and Dominique. If you're not on that list still, or you are supposed to be on that list, please let me know. But that's who I have still on this list. Leah, we'll start with you.
Me, Kazan. Let's do a do-over. Okay, so, you know, we have done really great work in this committee. I have to say, out of everything in the House of Commons, what I've enjoyed most is this committee, because we know how to work through things and get things done. And I think it's been of the benefit to voices that are historically marginalized in this place, and that's women and diverse gendered folks. They really have no place in here, especially with intersectionalities like women like myself. So this gives me place and purpose in this very misogynistic institution. So I want to start by saying that. I want to point out a couple of things. One, I think intimate partner still is included. If you look at A in G3 810.03, it says any person who fears reasonable grounds that another person will commit an offense that will cause harm to the intimate partner. I don't think it's taking out voice. It's looking at research in domestic violence, where people who are experiencing domestic violence are often, for whatever reason, too afraid to come forward. We will be doing a study on coercive control, and I'm sure that will be a centerpiece of the study on coercive control, which is, has massive implications that go beyond physical abuse, that the mental and psychological abuse is a form of control and power which will limit a victim's ability to feel like they can come forward for fear. So I think it actually supports getting at some of the roots of gender-based violence by really ensuring that we can save lives in this bill. And I know that when the senator, and I know we're bringing up former testimony, I was very touched by the senator. And this comes from his daughter's personal experience, who I suspect, for whatever reason, maybe felt like it wasn't safe for her to come forward. For whatever reasons, whether we think it's legitimate or not, we know through research that, and just lived experience, that often women will not come forward. So I think this change will save lives, in fact, when you say any. And it will help families support members that they see are in obviously abusive situations in a way that could potentially save their life. So I don't think that the senator would not approve of making amendments to a bill that, in honor of his daughter, that probably would have provided her with more safety. So I really support this amendment. The other thing is that we know that in cases of child abuse, that we all have a legal obligation to report suspected abuse of children. We are legally obligated, so I don't think this amendment moves away from legal obligations that we currently have, which is to report any suspected abuse to children. It's right? So that's where I'm at with it, knowing that everybody around the committee table has the best intentions to lift up the voices of victims. I want to acknowledge that. I don't think there's anything malicious in the discussion that's happening here. But I do think that if we're going to make a better bill and base it on research and base it on the facts, then I have to support this amendment, because I know this amendment will save lives. And I don't have a problem with D, because it's already required of me through law. Thank you.
Mark, Emanuela, Dominique, and then I'm going to bug Chelsea and Julia just to sum things up for us as well, unless there's other questions.
Yeah, thanks, Madam Chair. This is a very difficult process, and the testimony we heard. And I just wanted to, from some of the witnesses we've heard, it's not like we're gutting the bill, Michelle. It's we're trying to expand it and trying to improve it. And we've heard other witnesses, say that there was some tweaking and some little concerns. As Leah mentioned, you know, when we look at other persons, children, family, I think that's an improvement. You know, in the previous, we talked about victim services versus the prosecutor. There's a process. The bill focused on the prosecutor. We focused on the victim services in the courts. So I'll be supporting this amendment. I just wanted to, intimate partner is, in this amendment, is mentioned 4 times. In 810, Article 6D, 6E, and Article 7. And the change in 810, another person, and I'll ask well, Chair already said we'll turn it over to the officials, but again, adding that other person, I thought there was some confusion earlier comments that I think it's a good thing adding other person, not just the individual, the victim, because the children, the family, and so I think that's okay, and we'll ask the, and it doesn't, you know, it doesn't, so that we get this passed as soon as possible. With some of these they seem to be improving the bill, which is, I think, that everyone around this table wants.
Emanuela and Dom.
Thank you, Madam Chair. I just wanted to clarify because, you know, in saying that we heard from witnesses who want this bill unchanged, we ignore the fact that almost half of the testimony was hearing witnesses talk about how there was absolutely changes needed to this bill before we allow it to go forward. And those people were people who worked with underrepresented groups, were people who worked with, you know, Black women, Indigenous women, women who are overrepresented in prisons. So I think it's important that we are making these changes. Now, in terms of going back to the actual amendment on the floor, you know, we have been told by the legal team here that this doesn't exclude victims of IPV. So it's not that the victims themselves cannot come forward and ask for this. It is that we're increasing the chances that they will actually get a peace bond, because more than just one person can go and ask for it. It's anybody who may want to go and speak on behalf of the victim if the victim is feeling afraid of doing so herself, or herself. So yeah, thanks.
Thanks so much, Emanuela. So I'm going to pass it over to Chelsea and Julia. And just with G3, if you could just kind of give us a summary on how G3 impacts, because I know that there's lots of, not just the 81003, but if you could just say, kind of summarize how, round it all up, and how this would actually be better or worse or whatever it may be. If you could just provide your thoughts.
Sure. So the amendments proposed in G3 are technical in nature to make the new peace bond in line with the language used in other peace bonds that already exist. That consistency helps in terms of interpreting when you get before the courts by using the similar or same language. So obviously, as has been previously discussed, would allow a police officer, for example, to relay the information or bring the application. And then several of the provisions relate to renumbering. There is, did you want me to go through all of it because there's quite a lot, or is that sufficient?
Above stuff that's okay. That's something that's, we'll explain and we'll go, oh, okay, that's easy. Okay, yeah. Got it.
And then it would also remove, for example, the reference to a timely order. That the challenge with that is that it's not a defined term. So, and there's significant variability depending on the Canadian jurisdiction in which a peace bond is being sought in terms of how long it takes. So it might be challenging in terms of implementation. It's not included, but obviously I think the courts are aware that these are something, time is a consideration in this. It's an ongoing challenge in courts. The other thing is it allows, if we're varying conditions, as with some of the other peace bonds, it allows the Attorney General or the intimate partner, if the informant is not the intimate partner, to ask for the conditions to be varied. So that could be important. For example, if you have a new custody arrangement and there's a requirement that you need to communicate over transfer of the kids, that sort of thing. So the benefit of that is you can align and adjust as required depending on the situation of the family. Anything else you think of? No?
Comments? Seeing none, let me get to this annotated agenda. Shall G3 carry? And so that's carried just as unamended. All those in favor, can we get a recorded vote? It just might make it easier. Recorded vote, please.
Ms. Lampropoulos?
We're voting? Yeah, okay. In favor.
In favor. Monsieur Seri?
Oui.
Ms. Sidhu?
Yes.
Ms. Hepner? Ms. Vandenveld?
Yes.
Ms. Ferrari? No. Dr. Lewis?
No.
Madame Fien?
Non.
Madame Laroche?
Oui.
Ms. Gazan?
Yes.
7 yeas for 3 nays.
So G3 passes passes, period. G4, I'm going to pass it over, so that's 127-48365, and I'm going to pass it over to Sonia for interpretation for us, or some discussion. Sonia?
Madam Chair, replacing the word informant with the intimate partner, the parties in subsection 2, 7, 9, and 13. So just for the consistency with other subsection, with Madam Chair.
Okay, so this is going to be quite confusing. Although I've got it all marked out in my book, it is quite confusing. So just to let you know where you will find some of these. I believe G4 impacts appearances under section 2 on page 2. It has impact on, G4 has impact on conditions and recognizance. It has 7C is impacted by that. G4, those are the only two things I think it impacts. Is that correct? Is there another part?
It's just right here.
Just the appearances there, that's it? Then why did I put that there?
Madame la Présidente, est-ce que vous permettez, est-ce que Madame Sidhu...
Madam Chair, can Madam Sidhu explain, because I didn't understand and we were having issues with interpretation. The paper version that we had, we have the amendment for G4 in English only.
Ou en français aussi. You should have both.
No, under subsection.
Or this is English version only. Sorry. In here, Bill S205 in clause 2 be amended by replacing in the English version lines 15 and 16 on page 2. Okay, so that. Thank you very much. Yeah, go ahead.
When I came to this committee, I understood we were doing a clause by clause. There are a lot of clauses in G3 that we didn't even touch on, and you just voted on it. It was no, but there were a whole host of.
No, we voted on G3. So we did not.
I thought, but we
no,
only.
we did G3. We're not doing clause by clause. We just did G3, which carried. Then we go through the entire things. Once the clause, when it's an actual clause, then we'll go. Once the clause is finished, does the clause carry those types of things? So we're just in the preliminary work right now.
Does that make sense?
No.
So right now, you're taking. What we do is we take the amendments as they come in. They all get numbered accordingly to where they sit in here. We go clause by clause, but we have to do amendment by amendment, and then we can get into clause by clause. But we're amending what we need to because they are so consequential on other pieces.
Right, but we dealt with clause 1 in G3, correct?
Clause 1 in
Amendment.
G3, no, we dealt with,
Okay.
we already,
Because what about all of these
I know,
ones?
so, Chair.
What about all of
I
these
know what
ones?
she's asking.
Pages on different, on G3 does not only deal with page 2.
that's what I was saying, yeah. I actually had read that out because G3 had an impact. G3 had an impact on the fear of domestic violence, G3, and I read these ones out on 7E. 7, or 5, timelessness on 5. I had read those all out, indicating we had issues. G3 impacted all of these as well.
Right.
I
So-
think what she's asking, why didn't we vote individually on each one?
Well, no, we
Because
needed
you
to
cannot.
No,
You
but,
cannot.
but we didn't even have a discussion on them.
I agree. But when we're having that discussion, we're talking about G3 at the time. G3 is an entire one section.
No, I understand that.
And so we went through here and I read out every part of what pages were being impacted. And then because it's one amendment, at any time, you talk specifically to what that amendment may be at that time on that clause.
Right, we were dealing with a sub-amendment, which then was...
Defeated, yeah.
No, it was withdrawn, the sub-amendment.
withdrawn, sorry, yeah.
And then we were specifically speaking about the first paragraph. And then all of a sudden, there's a vote on the entire thing without further asking about whether or not...
Unfortunately, I did ask, trust me. No,
whether
one moment.
There were other clauses?
No, there's one amendment, but I listed out and I spoke and provided detail on every single clause right there that was impacted. I went through all of those 3 pages as it indicated that G3 had impacted 3 full pages. As I indicated, page 2, 3, and portions of 5 were all impacted. And I had actually showed all of these things were impacted.
Well, I'm just not content with that. I would like the record to show the objections that we had to the other clauses, because I think that should be in the record. Because there are a number of clauses that impact on C21 and also on Bill 233. So there are a number of clauses that impact on other bills, and
233 we never get under as G3. G3 does not have an impact on 233.
actually, are we not dealing? Well, maybe not in this one, but in general, there are other provisions that deal with monitoring, et cetera.
Yeah.
Right?
G3 specifically, because as we went through those are all listed. So what we
Right.
had to do, it had to do with taking that language that we had, that we just accepted here, talking about changing some of those words to any, and it made it so that the entire thing, as Julia had explained, the impact on all of those other clauses from the change of words that we were using in the first section of that.
But there, like, even if you look in Clause 8, there's huge impacts in things that are changed that we have not discussed, which is very, very important to the legislation.
I'm not disagreeing with you.
I would like an opportunity to put that on record, because we're dealing with people's lives, actually. I'm sorry?
So, no, okay, so the only way
your
for
vote
that...
could stand, but
Yeah,
I
vote can
think that I should have an opportunity to...
Okay, guys, I'm the only one who needs to speak. I thank you. But other than yourself, the fact is the only thing we can do now is ask for a UC. I will promise you, looking in this room, it's not happening.
Well, I could bring a point of order to raise these concerns. It is a point of order. We are dealing with an order of how this is put on the record. The record is very, very important. The order is very, very important to the record.
I have been advised that this would not be a point of order. Well, okay, so I hear what you're saying, but I also know that I did call out all of those lines, and I did actually bring them to everybody's attention in this room prior to inviting Ms. Nicol and Ms. Moore to discuss, because I said it's impacting more than just 810. It impacts this section and this section and this section. Mm-hmm. So when I read it out, I showed everybody my pages because...
But they're errors. They are actually errors. We are sitting in this room and we are putting forth, voting on things that are erroneous, that will make us look incompetent. There are actual errors. If you look at 8, deleting a clause 9 and putting in 7, which is dealing with one in bail terms and another in dealing with firearms. It's completely erroneous.
Now, the firearms section, just to let you know, is not, I do not believe it's in this part of this section, because that is one thing.
Right, but if you look at Clause 8, it refers to a provincial court judge adds a condition described in subsection. They change it to from subsection 9 to subsection 7, which originally dealt with firearms, and they're changing it to bail. It completely changes the legislation, and we are legislators, and this is very, very important. It is a point of order. This goes to the gravity of our job as legislators. We should not be just passing things through. This is what we do here. This is essentially what
Thank you very much, everybody. I've got the point of orders coming through. I am just going to suspend so I can speak with the clerk. Suspend. Okay, we're unsuspended. I would really like to, sorry, Chelsea and Julia, so that we can move forward, I really think it's important. Can you share with everybody the renumbering that is implemented because of G3? Because I know G3 does have that change, and all I'm like, it's okay because we go through it. I know some of those are 7 or 8 letters. I just want to provide them. What's that? What for?
We already voted on?
No, but they'll know when we come to the rest, the impact from those other ones, just so that we know how the line numbers have moved, and that will cause problems. So I want everybody to just let them know how the line numbers have. It's just how the line numbers have moved, or the clause numbers. Yeah. Go ahead, please.
So just to start out, G3 is only amending clause 2, right? And so if there are other amendments in other clauses that are caused by these amendments, those will be brought, from my understanding, through other motions. So it doesn't mean that the distinct or differences will remain. So one of the renumberings that probably the most helpful is once 5. So G3 removes sub 5 and sub 8. So sub 5 is about the timeliness of the order. Sub 8 is about the submissions. So once those are removed, that affects all the other numbering. And so basically, because of that, each of them changes. So once 5 is removed, then 6 becomes 5. 7 becomes 6. Then 8 is removed, sub 8, which is on page 4, which then means sub 9 becomes sub 7, because now there's 2 that have been removed, 2 subsections that have been removed, and then the same for the others until sub 14, which becomes sub 12. And that is just within clause 2. Does that clarify?
Excellent. Okay. Now, there was a list, and I've got what we have is Saray, Gazan, Lambropoulos. That's the list that we've got down here. For
So we're on G4?
G4.
So G4, I just wanted to, thanks, Madam Chair. I think G4 is simple. I know this is a tad, but it's a good debate, so that's good. But the as Sonia mentioned, the G4 amendment is only replacing the word informant. Okay, so you're taking the word informant and replacing it with terminology that says intimate partner and other parties. So I think that's a more inclusive term. So I think it's pretty, and it would affect subsections 2, 7, 9, and 13. So it's really, as Sonia mentioned, a terminology change. So I think it's pretty straightforward, and hopefully we could just move on to the next.
Okay, fantastic. Thank you so much. We'll move Leah, Emanuela, Adrienne, and Michelle.
Yes, and I think it goes back to what I was talking about before with any. So I do, yeah.
And Good. And Adrienne?
Madame la Présidente, mon sur...
Madam Chair, on G4, I would like to understand what the impact of adopting this amendment would be. It seems to align in English and French, but I would like to hear more on the impacts of it, please.
So, passing it over to our analysts. Go ahead.
Alors, le G4, comme...
So for G4, as you mentioned, the change would be more aligned with the French, and it's also terminology that is used in other peace bonds, and so it follows those other orders, those other peace bonds, rather. And so it's the same people.
Adrienne, any follow-up from that? No? Okay. Michelle?
I'm going to have to pass because now I don't even remember what I was going to say.
Well,
Thank
not
you.
a problem. Ms. Leslin.
It was really important, apparently.
I just
Yeah,
want to.
no, I've got Leslin, Lisa. I had it all listed down.
I just want to first thank the officials for that clarification. I think it is very important when someone sees something that appears to be an error that it's raised, and I thank you for just outlining exactly what happened with those paragraphs. So thank you so much. I just want to ask for another point of clarification. So, in this paragraph, we're dealing only with the informants. So I'm curious as to what the definition, and through you, Chair, I'd like Ms. Sidhu to perhaps clarify what changing the term informant to parties, what parties would include, because I would think that you're just dealing specifically with the informant, and who, like, what else would be included in parties, and why the necessity of the change if it's only informants?
Okay, the next on my list is Lisa, and if Sonia would like to respond, please put up your hand. Sonia or Lisa?
My point was actually kind of in the same vein. The whole reason we need this amendment is because we've just passed an amendment that says we're not leaving it up to the victim to ask for a peace bond. So because we've opened it up to parties, we need to clarify the language throughout. So that's all this does, is amend the language so it conforms with that previous amendment that we passed, which allows for multiple parties to apply for a peace bond on behalf of someone experiencing intimate partner violence. So that's the reason for it. It's necessary because the language will conform then with the previous amendment.
Maybe I could seek some clarification on the word parties, because my understanding is that parties could mean every party. So wouldn't it be better to have party with a Y and then bracket S, because this clause specifically deals with the informant. So the informant could literally be any of the members of the party, and it would still be all encompassing. But when you change it to the word parties, it is all inclusive to all of the parties, and I think it is an error. So I'm just seeking clarification on that.
Before we do that, Leslin, can I take you home so you can talk to my children so they understand these words? Because I really do appreciate getting this. Actually, I'm going to move it over to just, you know, when you're talking about words, how important they are. I'm going to pass it over to Chelsea and Julia, please.
Hi, thank you so much for the question. So this provision of the new peace bond regime sort of allows the judge to call upon the parties to come for a hearing. So it's different than the first provision under 810. I sort of look with the bill alongside the motion to understand, to situate the change that's going to be done. So it's the provision that's called appearances. And so the judge there has the obligation, once they receive the information, to call all the parties, so the defendant and the person who made the application for the peace bond, to come to a hearing. And at that point, the judge is going to hear from both sides and determine if there's been a reasonable fear. The French version already had the word parties in it. The French version already had the sort of succinct way of summarizing all the different people that need to come. And so the intent here is really to just ensure consistency with the French version of the bill on this provision. That's pretty much it.
Sonia, you had your hand up and put it back down. Did you want to comment?
Madam Chair, I think official explained very well. It's because we just amended to law multiple parties to apply for peace bond. Lisa explained very well. I think Ms. Leslie now can understand that. It's about consistency and thanks. I want to thank officials. Thank you, Madam Chair.
Any other questions or comments on G4? Seeing none, does G4 carry? G4 carry? Okay. Just looking at everybody, because so we'll go a recorded vote, and then I get everybody's attention at the same time. Recorded vote.
Ms. Lampropoulos?
Yes.
Monsieur Serré?
Oui.
Ms. Sidhu?
Yes.
Ms. Hefner? Oui. Ms. Vandenbeld?
Yes.
Ms. Ferrari?
No.
Dr. Lewis?
No.
Madame Vien? No. Madame Laroche?
Oui.
Ms. Gazan?
Yes.
7 yeas, 3 nays.
So G5 carries. Okay. G4. Well, golly gee, guys, I don't know what day it is, let alone what number we're on. So you said G4. Fantastic. Thank you so much. CPC 1. What's that? What amendment? Dr. Lewis, we had reference number 127-67903, which was your amendment, which was a CPC 1. It was regarding, it was, I believe it had a lot of correlation to do with your sub-amendment for G3. Would you like to move that or not?
Did I not withdraw the sub-amendment?
You withdrew your sub-amendment, but you have CPC 1 in as well.
But isn't it related, so that not be moot now?
You don't have to move it then if you don't want to.
Okay. I'm just, was it not related to the one that I withdrew? Okay.
Yeah, you're right, foreman and reasonable grants. Okay, so we will move past that then. In order to be coherent throughout the bill, gosh, okay, that does. G5, can everybody turn to G5? And the mover of G5, I believe, is Sonia. Sonia, I'll throw you on the floor for G5, please.
Thank you, Madam Chair. I'm not reading the full amendment because the members have it. To speak on the rationale, we all share the objective of protecting victims of intimate partner violence. We all want women and victims of intimate partner violence to be well protected by the law. There are many peace bond provisions in the criminal code, but it is important that we ensure consistency and coherency across the board.
Be sure that I've got this right. Sorry, my own issues. I have my own issues for a second, but what I see as I immediately look up, I see Michelle, I see Leslyn, I see Adrian. So we'll start that with Michelle okay.
So again, just because I've actually never done a clause by clause or amendments in this format before, it's been not done like this. So I just want to be sure that I know what Ms. Sidhu is putting forward. So if we're on page 2, replacing line 23, where is this not for? Okay, so. Thank you so much. Thank you for that. The judge may order the defendant to enter into the recognizance for a period of not more than 3 years, but Ms. Sidhu is asking to amend it to say not more than 12 months. Can I just ask through you, Chair, why?
So I will put up, if anyone has, here we have, I got this list here. We have Michelle, Leslyn, Adrian, followed by Lisa, and Sonia, if you'd like to respond, you can. So we'll go on to Leslyn.
I essentially had the same question. If the aim is to protect women, why are we reducing the term of recognizance? And is it because we've had flexibilities elsewhere? I'm just trying to understand what the rationale is for reducing it substantially from 3 years to not more than 12 months.
Adrian, followed by Lisa, and then Sonia, I think you want.
So, Madam Chair, it's my turn. Should I just...
No, actually, what I will do is I'm going to give you the floor as we go through. Adrian, followed by Lisa, followed by Sonia.
Non, mais de toute façon, les questions sont là.
I understood that in the original it was 2 years. Now we're looking at 12 months for a peace bond. And I'm trying to understand what the link is with the consequences, or perhaps our experts can explain what would be safer for victims.
do is I know we'll be coming a lot back to you, the two of you, so we'll try to get some information out here. So Lisa, Sonia, Dominique, and then over to our experts. Oh, and Michelle, oh no, I'm sorry, Michelle, then experts, because I had the M here. Go ahead.
Chair. So the way I understand this amendment, it would drop the peace bond time length, but just to put it more in line with other laws that are already on the books. So I'm wondering also from the experts in the room, if you could sort of explain to us if that's important to bring our peace bond requirements in line with other laws and the rest of the criminal code, and what sort of effect that would have.
Okay, then on to Sonia. Sonia?
Madam Chair, as Lisa explained, I think that if the official explained, then we'll see after that.
Excellent.
I think
I'm
the
going to
official
have.
can explain it very well. Yeah.
Okay, so, okay. Go ahead, Michelle.
So if I'm clear, and again, I defer to my very esteemed colleague, Miss Lewis, with her legal background of being a lawyer. I'm not a lawyer. But the way that this amendment that has been put forward by Ms. Sadu is that instead of saying 2 years, you're saying 12 months, which is reducing. And that just doesn't make sense when we're here, when we're supposed to be fighting for victims. I can't get my head wrapped around this. And I think I want to read into the record a little bit more, because I think it's critical that we have the victim testimony on file.
I think we've heard the victim testimony. We all heard it. I don't know if it's a good use of our time to rehear it.
I think we're here for victims, so I think it's absolutely.
I think as the chair, I will say I'm sorry. I think it. Yeah, I do believe it's fine to listen to witness testimony. That's how we're backing up our amendments.
That's
Go
wild that you don't want to listen to victims. Okay, so over the past 20 years, I've worked with hundreds of women. This is the victim testimony that was given to us by Miss Diane, by Miss Martine Jensen. And so she said, over the past 20 years, I've worked with hundreds of women who needed help. There is no way to hide them. Men can track them down at their place of work or through their family. They can follow children to school or to their friends' homes. The man will never stop stalking them, following them, harassing them, and harming them until an electronic bracelet is required. Women and their children will never be protected. Electronic bracelets may not be perfect, but that's all we have for the time being. We have no protection. That's why we are asking on behalf of all women to pass this bill. So I just, again, I'm not clear on why we want to reduce time for criminals. It makes no sense.
Dominique, you have the floor.
Merci, Karen. Totalement en accord avec.
Thank you, Karen. I agree entirely with Michelle.
Translation?
So sorry.
That's okay.
You did nothing wrong.
Gazan, I thought you were going to give me a hard time, eh? Okay. You don't have translation. Okay. Are we good for translation now? Can you hear?
Est-ce que ça fonctionne, Leila?
Wait.
Are you hearing interpretation now? Are you hearing me when I say that you're great? I think that I don't understand why we're going from 2 years to 12 months and 3 years to 2 years with G5. In an 810, when we talk about peace bonds and having good behavior, I think that it should be forever, and I don't think that we should decrease this timeline unless it's contradicting another part of the legislation. But I think here we're talking about a very minimum requirement. Thank you.
We will go to the experts, and then I know Dr. Lewis and Leah both have comments. The experts, we're here with you guys.
Thank you so much for the question. So the provisions in the bill as drafted right now currently allow for the peace bond, the new peace bond for intimate partner violence, to be imposed for a duration of 2 years in any case where the court finds that there's a reasonable fear of domestic violence, or 3 years if they make the determination and the defendant has a prior conviction as well for intimate partner violence. So currently in the criminal code, the peace bond that victims typically go to for intimate partner violence is the regular 810 peace bond. That is for 12 months only and doesn't have a provision that would allow it to be extended at all. The other existing specialized peace bonds in the code, so there's 5. There's a peace bond for terrorism, organized crime, forced marriage, serious personal injury offenses, and sexual offenses against a minor. All start at 12 months, as well as the 810 peace bond, and allow that peace bond to be extended to 2 years where there's a prior conviction for a similar offense, except for terrorism, which can be extended to 5 years. But for example, a serious personal injury offense can only be extended up to 2 years where there's a prior conviction for similar conduct. A serious personal injury offense is an offense that's more serious than the personal injury offense that's the subject matter of this bill. The policy surrounding specific peace bond durations, just by way of background, has been developed by the courts while being mindful of the seriousness of the specific conduct triggering the peace bond, while also being mindful of the purpose of the peace bond regime, which is to prevent offending in a minimally impairing way, since no actual offense has taken place yet. And just a reminder that while the person is subject to the peace bond, they could have conditions to attend treatment, for example, to wear an electronic monitoring bracelet. So when we're talking about the duration of the peace bond, we're really talking about how long they need to be subject to some of these conditions that they're on. So I think just to sort of summarize the changes, the changes in this motion G5 would sort of ensure that the current durations are in line with the durations for other even more serious peace bonds in the code, but also taking into account sort of the principles underlying the peace bond regime that have been set out by the courts. Thank you.
Thank you very much for giving that. On the list we have Leslyn, Leah, and then Mark.
So, yeah, Section 810 is usually the normal peace bond. So, it admittedly, 12 months is, I've never seen it, the legislation does contemplate something which is outside of the norm of Section 810, which is a peace bond section that would ordinarily be invoked in these types of incidences. However, I think it's important for us to understand why the drafter contemplated an extra time. And, I'm going to refer to my esteemed colleague, Ms. Gazan, who eloquently stated that laws for children have different reporting or duty to report requirements. And so that has been modified, and I'm not trying to infantilize women and put them in the same category as children. But when we're dealing with intimate partners, I would like perhaps if the experts could explain to us why this would not be an exception outside of the regular 810 peace bond, because I'm sure that the drafter of the legislation would have known what the normal course of the peace bond would be, and perhaps just explain the difference between the fact that these individuals wouldn't have been convicted of an offense as yet when this is invoked. Is that correct?
Yeah, I'm going to pass it over. Yeah, I want to pass it back to you so that you can answer specifically on these questions. Go ahead.
Thank you for the question. So yes, no criminal offense has been committed in the, sort of the peace bond context. So if someone was actually convicted of an offense, a personal injury offense towards an intimate partner, they would be looking at possibly a much longer sentence, possibly 10 years, depending on the context. But here it's really there's been no offense, and the purpose of the peace bond is to prevent an offense from possibly occurring. The difference with the 810, the peace bond, what this bill would add would allow the peace bond to be extended longer than the regular 810 peace bond. The regular 810 peace bond right now doesn't allow for an extension of the peace bond. The other thing that this bill would add, from my assessment of reading it, is that there would sort of be more curated conditions that could be imposed that relate to domestic violence in this bill, like things like treatment for domestic violence, counseling, electronic monitoring, things like that, which are sort of more unique to domestic violence. So there's some more curated conditions with this new peace bond.
I have another question. So, in a situation where, and oftentimes, sometimes the accused voluntarily also enters into a peace bond, and it's a means of resolving the conflict. So, in a situation whereby someone has not been charged, or there's no offense that has been on the books, and a peace bond is basically a bond of the person to enter into peace with the other individual. Yet we're imposing all of these conditions. Could that not be a deprivation of like, say, Section 7 charter rights, different aspects of the charter? Because there's absolutely no requirement for that person to submit to counseling and all of these requirements that could be attached to that. So that's my question.
Thanks. The existing peace bonds in the code that have this duration of 12 months with possibly extension if there's a prior conviction have been upheld as constitutional. So it does provide some comfort in terms of how the peace bond regime is compatible with the charter. It's difficult to speculate what courts would find if there were, for example, an indeterminate peace bond. How would courts handle that? Under the charters is difficult to say, but all I can say right now is that the existing regime has been found to be consistent with the charter, and this motion would ensure that what's being proposed here is consistent with that existing regime as well.
Belabor, but the existing regime, usually conditions are imposed after a finding of guilt or some terms. So, but my question is, and I do know that sometimes they work in some good behavior conditions within the peace bond, but this seems to be going a little bit beyond that, and I'm just concerned about whether or not this could even stand up in a court under freedom, the liberty provisions of the charter.
So there's in the peace bond context, there's no finding of guilt, but as you say, sometimes people go for a peace bond midway through trial.
Right.
They realize, maybe the case isn't strong enough. They decide to settle on sort of a peace bond arrangement. But there's no finding of guilt. There's no criminal offense that's been acknowledged when a peace bond is signed. There's a sort of a determination that the person applying for the peace bond has a fear that an offense might be committed, but there's no offense that's been acknowledged. The conditions that are imposed as under a peace bond, there's sort of this provision at the very beginning, paragraph at the top before the conditions that reads that the judge must ensure that the conditions that are imposed are reasonable, and that they are desirable to ensure either the good conduct of the defendant or to secure the safety and security of the informant. So that sort of guides the judge in ensuring that the conditions that are imposed are reasonable and sort of in line with the jurisprudence that's been developed. It's sort of like a check on ensuring that the conditions imposed wouldn't breach the charter or other rules developed in the common law.
Thank you very much. Leah, you're next.
Yeah,
I did check my watch.
I just noticed that.
5:29, lady, but.
Is that, can I talk?
Go ahead, get your question
Okay,
out there.
so,
It's 5:29. You make every minute work.
Just one question I have. I know that we're talking about the peace bond. That's consistent with the current laws, right, on peace bonds? Okay, so there's a consistency. And then the other point, I think, in terms of bringing up testimony was with NWAC. They suggested multiple time alternatives to justice, like restorative justice, measures that were culturally appropriate, partly because we know that penitentiaries, which I have done some work in, are quite violent and antisocial and really don't do a good job fixing particularly individuals that are dealing with violent behaviors. And so they spoke about alternative forms of justice rather than incarceration. I heard that loud and clear from a lot of the witness testimony. So I don't think it's about not punishing, it's about looking at alternative forms of justice, something that is actually been around Manitoba for a long time and has been very effective. Restorative justice, particularly with Indigenous peoples, looking at root issues like intergenerational impacts of colonization or first-hand impacts of colonization. Just because I know we're all trying to make things better for women and diverse gendered people, I don't think anybody around this table is different on that. I think we've demonstrated that over and over again, even though we're in different parties and have different angles. I know that we have a common goal. So, I mean, that's my perspective on it. Not that I don't think that we should take it seriously. It's just I have to look at research that I've been involved in, programs that I've helped develop in this area, and you see less recidivism rather than just throwing somebody in jail in the most violent antisocial environment imaginable. Yeah. Thank you.
Looking at the clock, we are past 5. I have a few more people on my list. Recognizing that there will be no way we're going to get through S205 today, I'm going to ask shortly to adjourn. But I'm going to let you know that I had a great walkover with a PS who said, hey, what's Thursday looking like? And with everybody's agreement, Thursday's meeting will be canceled, okay? So that we can continue on with everything. Should have made their day. She thought it would make your day. I thought I would never know. It might get angry. Anyway, seeing that we have no further business today, I call this meeting adjourned. Thank you, guys. Okay. you.